Well, good morning, and thank you so much for joining us for our fifth annual Southern California Trial Lawyers Conference. As President Gash said, I'm Rebecca Malzahn, and I serve here as the Assistant Vice Chancellor and Senior Director of Advancement. I am not a trial lawyer, so my remarks will be very short. We're excited to get started, and before we do, I wanted to pause and take a moment to thank our sponsors. This day would not be possible without our sponsors. So the Simon Law Group, thank you. Hippler and Hippler, thank you. Chernoff, Bedart, and Echeverria, thank you. Lawland Law, thanks, Lori. Quest Settlements, and the Paris Law Firm. Thank you so much to all of our sponsors. As Paul alluded to, for this conference alone, we've raised over $130,000 that will directly benefit our trial advocacy teams here. So we're deeply grateful. Before I turn the program over to Spencer Wolf, our organizer, I also wanted to pay respect to our vendors who are here in between sessions. And then during lunch, they're going to be out in our foyer. So Quest Settlements will be there. Chart Squad, Apex Chat, Verdict Videos, and Case Peer. So be sure to stop by the tables in the foyer to learn more about how they can help you in your practice. I also wanted to thank our teams here, Bliss Corley Mosier, our events team, our tech team, and then Spencer Wolf. Thank you so much for everything that you guys have done to make today possible. So without further ado, we want to get started. Spencer, come up and kick us off.
Thank you for the applause. It wasn't necessary. I've already been up here. To run you through today, so give a little bit of a breakdown, folks. I'm a graduate of the law school of the 2019 class. I took the July bar. I passed the bar. I'm now a new minted Pepperdine licensed attorney, and I'm very excited to be here in that role. I'm here working short time in our Alumni Affairs Department for somebody many of you may be familiar with, Jessie Faye, who is currently out on maternity leave, having just had her second set of twins. So we keep her in our thoughts and prayers constantly, and we love her dearly. Actually, as my first true career step, I will be moving on to Army JAG in August and going to boot camp. But I'm blessed to have the opportunity to be here at the school that I love dearly, supporting the programs and things here. As a former president of our trial advocacy team and a student who competed in 9 different advocacy competitions during my time at Pepperdine, I recognize how beneficial this program really is, this conference is, to the success of Pepperdine and our advocacy teams. So I thank all of you, our sponsors, our vendors, our attendees. You guys make our teams possible. So thank you for that. In that light, and recognizing what I think is a great presentation and what we've done in this conference in years past is providing not just panels and discussions from individuals who are incredibly intelligent and well-versed in what they're doing, but also exhibitions. Individuals demonstrating their practice of law on the spot in the same way that they would do in the courtroom. So today you'll be seeing opening statements that will be used and have been used at trial. You'll be seeing closing arguments that have been used at successful trials from these attorneys. You'll be hearing from attorneys about the building and the development of your own practice and what steps are necessary to find that path for yourself. We're very excited about those panels today, and we'll introduce those speakers step by step as we go along. But first and foremost, to get us to our first panel, I want to let everybody know that while it states in the program that we have Justice Tricia Bigelow and Judge Judy Meyer on the panel, unfortunately, Judge Meyer is not available today. She is unfortunately not, she's under the weather and says that she has no voice. So we are very sad and feel keeping our thoughts with Judge Meyer, but we're very excited to introduce Justice Bigelow. And in order to do that, we're going to invite up one of our alums, one of my dear friends, somebody I've known for years, and one of our sponsors of this event, Mr. Mark Kepler.
Thank you. Tricia Bigelow is the presiding justice of the 2nd District Court of Appeal, Division 8. Before her elevation, she presided over the general jurisdiction fast track of civil trials and long cause criminal trials in the Los Angeles Superior Court. In 2015, Justice Bigelow received the Bernard S. Jefferson Award for Distinguished Service to Judicial Education. She is the teacher of all judges in California. She was awarded the California Judicial Council Ronald M. George Award for Judicial Excellence with honors for judiciary excellence, an equivalent of the Appellate Justice of the Year Award, and it's a statewide award that she received. She was dean of the annual Bernard E. Whitkin Judicial College from 206 to 208. So today we're so honored because she's usually teaching judges, and so she's here with lawyers and law students giving of her time. Presiding Justice Bigelow has written educational materials and lectured to a wide variety of groups, including judges, lawyers, and has instructed on jury instructions and written them. She's published many different written and oral video training materials for judges. And in 2018, just the recent graduation, she was awarded the Pepperdine Alumnus of the Year Award. Before her appointment to the bench, Presiding Justice Bigelow was a Deputy Attorney General for the state of California and presented oral arguments before the California Court of Appeals, the California Supreme Court, and the Ninth Circuit Court of Appeals. She was promoted to Special Prosecutions Unit and cross-designated as both a Los Angeles Deputy District Attorney and an Assistant United States Attorney. A very rare type of position that was created just because of her talents, her background, and her experience. But most importantly, my memory of Tricia is as a third-year law student at the very top of her class, and everybody knew Tricia. And she had the humility to spend a lot of time voluntarily working with some of us struggling first years. And she may never even remember that, but the impression that she made on us reflected Pepperdine and continues to reflect Pepperdine, that someone at that level would have mercy on the struggling first years. And I know we have a few of you here today. To this very day, she continues to work with lawyers and students to improve them. And as you can tell from the wealth of her background, her skill, her training, her knowledge, she is an invaluable resource to each of us who are blessed to have graduated from Pepperdine. Will you welcome Justice Bigelow?
Good morning. Great to see you all. I'm going to talk and start off talking about opening statements. And I think the first thing I have to say about opening statements is that they are very important. It's your very first chance to talk to jurors as a group and as a whole. And it's often said that a case is won or lost in opening statement. Jurors frequently base their decisions about a case just on what you say in opening statement. Well, in the course of my experience, I've either sat on, tried, or read the transcripts of hundreds of opening statements. And as a result of that, I'm taking that experience. I'm going to give you a few pointers that I have from the bench, from what I see is what makes up an effective opening statement. Before you see the real pros, give an example of what a good opening statement looks like. The first thing I think you need to do in opening statement is just tell a story. Keep it in your mind that you are a storyteller and you need to grab the jury's attention by the story that you are going to tell them. The key to a successful opening statement is a compelling, coherent narrative, or for the defense, a compelling counter narrative built on simple, engaging, and forceful presentation of the theme of your case. So, how the heck do you do that, right? Well, as I said, pretend like you're telling a story to the jury and do it chronologically, either from the viewpoint of the plaintiff or the viewpoint of the defendant. I think also you should keep in mind to keep it simple, simple, simple. Remember who your audience is. Your audience is a group of people from the community. These are not like you're trying to speak to an erudite group of Supreme Court justices. So use plain language, be monosyllabic where you can be, and speak to them like regular people. Have a beginning, a middle, and an end. Use words and expressions that can be understood by jurors who do not have advanced degrees, people who do not even have college degrees. In telling your story, my suggestion is that you make it vivid. Recreate the incident and do so in an emotional and somewhat dramatic point of view. When you're preparing your opening statement, you should think about the case as a whole. Think about who the most important players are in your case and focus on people. You can connect with the jury when you tell them an enjoyable story. I'm sure you'll see the practice opening statements given by counsel, and they're going to be telling you stories and looking you straight in the eye. When you're talking, I suggest you not waste time. Too many lawyers act like opening statement is a laundry list and your chance to give the jury every single fact you possibly can. Keep in mind that no movie, no book, and no play gives the whole story and every single detail in the opening chapter or the first act. So don't present too much information so that it ends up that you have given the jurors so much that they can't absorb it all, or heaven forbid that you should lose their attention. And gosh, avoid dry topics. Like I'm going to tell you about the history of the jury system in the United States. I think it's good, again, when you're preparing for opening statement, that you can put it in this story form. And when you do that, create a theme that you can hearken back to in your case and in your closing. I think that it's good to have really be able to distill that to a one sentence statement. So for example, in a products liability case, you can stand up and say to the jury, this is about Marianne, who lost her arm because BAD company didn't take the time to figure out whether or not their machine was working properly and take the time that they should have. And that encapsulates really what you want to say to the jury. And then you build your case around that. As I said, hearken back to that theme where appropriate, so the jurors remember what you said in opening statement. I think also, from what I've seen, it's not effective to simply read your opening statement to the jury. This is one of the few chances you have to look jurors in the eye and talk to them. And when you look someone in the eye and you talk to them, you have more credibility. They believe you more likely. So what I think you should do is practice. If you have friends, practice with them. If you don't have friends, look in the mirror and practice in the mirror, right? Or at a minimum, please go and practice with the lawyers in your firm. And also, I think it's very good to start out with your opening with something that you can, if you start at the very beginning with your theme and you look the jury in the eye, at least for the first few paragraphs of what would synopsize your opening statement, and also have a really set idea of what you're going to say in the final closing such that you can look the jurors in the eye, that's going to be really effective. If you need notes, and heck, I do, use an outline. Write down the major points that you have and do not write it down verbatim. Watch this. If you have a verbatim script, you are more likely to want to read your opening. If you use an outline, you can briefly review it as you go along with your story and make sure you haven't missed a big point. Versus, if you have a verbatim script, you're going to be so much more likely to want to look at that script and not look at the jury. If you use an outline, you'll be able to look at the jury more effectively and just check that you've not missed a major point. Which one to you looks more effective? Here's a good question that lawyers need to ask themselves. What do you do about bad facts? You have to make a decision. Am I going to bring up those bad facts in opening, or am I going to wait and deal with them when they come up in trial? My personal opinion is if it's a really bad fact, take care of it right away and do it in opening. I think you have to. You'll gain credibility with the jury. If you decide to do this and address the bad facts, make them personable, make them seem to the jury like anyone could have had those bad facts. So for example, if your client's going to be impeached for a prior conviction, say for selling methamphetamine, which sounds really bad and goes to moral turpitude, so it would be admitted, maybe you should say something like this. You're going to find out my client had a drug problem. It's true. Many people in America deal with addiction issues. My client had a drug issue, and it was part of a foolhardy youth. But do you know what my client has done since then? My client is sober. My client is helping other sober people. We have all made mistakes. I don't think any of you want our mistakes to be held against us and forever. So you're going to hear about this, but I want you to keep in mind my client's a changed man and truthful. I don't think it means he shouldn't be believed. Versus defense counsel standing up and saying, after you've given your persuasive argument, do you know what plaintiff's counsel forgot to tell you? This person who's going to talk to you about what happened, well, he's previously been convicted of selling drugs. Okay? Is that who you want to believe in? So make your decision about what you want to do with bad facts, but I think that that's something you really need to think about. When they're really bad, bring them up. I suggest also you speak in a manner that's consonant with your own personality. Jurors like authenticity, and we're all different. So don't try to be someone that you're not. If you have a Texas twang, don't try and lose it. Just use your Texas twang and use it to make it seem like you are the most friendly Texas person in the whole world. Be comfortable in your own skin. If you're shy, don't try to be so commanding. Just use your shyness in a way that works. So be who you are. Be the best trial lawyer you can be, not the best trial lawyer that you've seen. Another thing you want to do is be prepared so you don't get interrupted. Be sure your technology is working if you're going to use it. If it's a PowerPoint, if it's a video deposition, have your tech people in there first. Check it through, make it's working, so you don't stop in the middle and say, excuse me, ladies and gentlemen, jury, I'm sorry. We're having technical problems, and you get your person in there to do it, and the jury's sitting there waiting on you. Be prepared for that. Also, I think you should get court approval if you're going to present pieces of evidence or some type of exhibit. So show it to defense counsel, tell the judge ahead of time, I'm going to use this. Let me know. Is this okay? Everybody, tell me your objections now, so it's not when you're using it in the middle of your performance or your opening statement, I should say, that the other side objects and says, hey, counsel is standing up here showing something to the jury and I object. I've never even seen it before. Again, it takes away your credibility. You don't want to be interrupted that way. Also, know your judge. Know what your judge allows in opening statement. Find out how your judge feels about leaving the podium. Some judges who are in the federal courts or are former federal prosecutors will not let you leave the podium. Other judges will let you walk around the courtroom, but they may not like you to leave, the general area of the podium. So talk to your judge, have a conversation. What do you allow? Because again, you don't want the judge saying to you, excuse me, counsel, get back behind that podium. A one hot tip from the Court of Appeals perspective, we read opening statements when we go to resolve a case. We read them because it gives us a flavor of the whole case. So remember, when you're speaking an opening statement, you're not just speaking to the jury, you're also speaking to us at the Court of Appeal. And if you want your verdict to stand, I suggest that you keep that in mind. The last thing I want to say is that be sure to end by asking for what it is that you want. You want the jury to roll in your favor. So you need to say this to the jury. In this trial, we are going to end up by asking you to grant a civil protection order, or we're going to be asking you to give us what my client deserves, and that's a verdict in his or her favor. Those are my tips for opening statement from my years of experience, and I'm going to turn it over now to a few trial lawyers who are going to talk to you and actually give opening statements. And I want to introduce to you who those people are. The first is Spencer Lucas. Spencer Lucas has his JD in 2004 from Pepperdine, I believe. Great. He's a trial lawyer at a really renowned plaintiff's firm, Shea and Boyle, specializing in litigating complex catastrophic injury, products liability, wrongful death, sexual abuse, and sexual assault cases. He has successfully recovered more than $400 million for his clients. Wow. He prides himself on helping survivors of trauma and families to recover from tragic situations. His work in the courtroom has earned him nominations from really the premier plaintiffs bar, which is the Consumer Attorneys Consumer Attorneys of California. He was nominated for the Trial of the Year by them. He's also received recognition from them as a finalist for Trial Lawyer of the Year. He specialized and has been recognized, he's been recognized as Best Lawyer in America by Best Lawyers and a Super Lawyer by the Super Lawyers organization. Before attending Pepperdine University School of Law, he received his BA in Business Administration from University of Washington. Mr. Spencer, do you want to come down and take your seat? Yeah, okay, great. The other attorney who's going to give for you an opening statement is Amy Rose Martell, who joined Sheehawk and Martell in 2008 and was made a partner of that firm in 2016. Amy has been practicing civil litigation since 2003. She's currently a member of the California Bar of Consumer Attorneys of San Diego and the San Diego Bar Association and the Nevada Bar Association. She served on the board of directors of the Travelers Aid Society since 2003, which is a private nonprofit agency that provides crisis and short-term assistance for food, shelter, and transportation, as well as advice and resources for San Diegans in need. Worthwhile cause. Martell is currently serving as president-elect of the board of directors of the Consumer Attorneys of San Diego and has served as secretary and treasurer of that same organization. Without further ado, let me introduce to you Amy Rose Martell. Lucky for you, I'm going to be your judge. Haven't been on the trial court in 12 years, but I think I can still do it. So who's attorney for the plaintiff? You are.
Thank you.
Okay, sure.
It's really an honor for me to be back here at Pepperdine, so I just want to thank everyone for putting this together, especially another Spencer. Appreciate that. All right, so I'm actually in trial right now in Pasadena. I'll be picking a jury on Monday. So I was up late last night trying to condense my opening into 20 minutes. So here goes. May it please the court and counsel. Ladies and gentlemen of the jury, thank you for your time and attention so far. And I'm going to get right to it. What this whole case boils down to is a driver must always pay attention and drive at a safe speed. And if they don't, And if the driver strikes a pedestrian, well, then the driver is responsible for the harm caused. That's what this whole case is about, plain and simple. Now, let me tell you the story of what happened to my client, Nancy Fannin. On July 13th, 2016, the defendant in this case, her name was Samantha George, a 21-year-old woman in town on business. She's from North Carolina, and she's a pizza maker who's doing some corporate training. She's driving a rental car back to the hotel where she had been staying. So Miss George, she's in Pasadena, driving on Colorado Boulevard. She takes a right-hand turn into this parking lot of the Holiday Inn Express. So Miss George, driving a Ford Fiesta, turns right into the parking lot. And in the parking lot, there's stalls on the right to park cars, and there's stalls on the left. And what does Miss George do? She accelerates through the parking lot. And she's trying to get to the back of the parking lot where there's a parking structure behind the entrance. Now, meanwhile, my client, Nancy Fannin, 56-year-old woman, also in town on business. She was a regional director of a bunch of hospitals all across the West Coast. Now, Ms. Fannin had been staying at the Holiday Inn Express. After a long day on the job, sales meetings, Ms. Fannin parks her car right where that silver car is by that tree. Okay? Ms. Fannin gets out of her car, grabs her laptop bag, locks the car. She starts walking past 5 or 6 parked cars. She's walking down towards the entrance of the hotel when all of a sudden, bam, she gets clipped on her left side by the passenger side of Miss George's vehicle. Right where that side view mirror is on the passenger side, clips her right on the hip. And Miss George, as she's walking, her back, she can't see the car. She's walking like this along the back of the parked cars. She takes a step with her left foot, and as she gets clipped with such force, her body rotates and it causes her ankle to roll, and she suffers a severe fracture of her ankle that's so bad her shin bone actually dislocates from the ankle and pops right through the skin, all the way through. The car's going so fast that she rotates like this, breaks her ankle, she falls down, smash, right on her left shoulder, and she suffers a severely fractured humerus bone right there in the socket into 4 pieces. So you're going to hear some medical evidence in this case that I put together, but it is undisputed in this case that Ms. Fannin has suffered lifelong permanent injuries, and we'll be asking for a substantial multi-million-dollar verdict in this case to compensate Ms. Fannin for everything that she's been through and will go through for the rest of her life. So to start off with, ladies and gentlemen, the defendants in this case, I'm going to show you who they are. First of all, this company, Camden Blaze LLC, also known as Carolina's Restaurant Holdings, they were the employer of this woman, 21-year-old Samantha George. And it is undisputed in this case that Miss George was in the course and scope of her employment at the time when the incident occurred. And what that means is that the company is responsible for the harm that was caused. All right, now the plaintiff, Nancy Fannin, she was actually 56 on July 13th. 2 days later, when she was in the hospital, she turned 57. She's been married for 38 years to a gentleman named Jim, who's a local newscaster in Reno where they live. She has 2 grown sons, and she's a new grandmother. She's got a 2-year-old little grandson now. She spent 18 years with the same company called Rotech, where she was the senior area director in the field of respiratory therapy. And she was an active woman. She loved the outdoors. She was a strong lady, 6'1", and she loved outdoor hiking, camping, traveling. She was an avid fisherwoman. Now, these are some undisputed facts in the case. To start with, this parking lot, this is a retail area with many different retail establishments with lots of pedestrians coming and going. Next, no dispute that Miss George was actually accelerating to get all the way through the parking lot to park in the back behind the entrance. Now, it's undisputed that a safe speed in this parking lot is only 5 miles per hour. When there's no posted speed limit, the safe assumption is 5 miles per hour. And Miss George told the police at the scene after the incident that she thought she was going between 15 and 20 miles per hour at the time of the impact. Next, there's no dispute that Miss Fannin, she parked north of where the incident occurred and that she was walking south with her back to the oncoming vehicle. No dispute that Miss George had a very clear view of everything that was up ahead of her. It was about 5:40 in the afternoon in July. No real sun glare, no obstructions of her vision. But despite that clear view, Miss George testified she never saw Miss Fannin, never even saw her until after the impact. And the evidence will show that's because Miss George was completely distracted. No dispute that Miss George's vehicle struck the pedestrian, Miss Fannin. And there's significant damage only to that passenger mirror and the side door. And that's going to become an important piece of physical evidence in the case for you all to consider. And again, no dispute about the horrific injuries in this case. All right, now, in cases like this, when there's physical evidence, there's engineering analysis that needs to be done. And the plaintiff, we have retained this expert, Alvin Lowy, to do a reconstruction of the engineering and the dynamics of how this collision occurred. This is some of the work that Mr. Lowy has done. And as you can see here, this blue outline, that's the area of the parking lot where we're going to be doing the engineering analysis. So I'll go through some of these slides with you. Now what we can see here, the green circle on the left, that's Miss George's vehicle on Colorado Boulevard, right before she makes that right turn into the parking lot. And this yellow circle here in that red car, that little dot right there, that's Miss Fannin exiting her vehicle. And as you can see, Miss Fannin is going to walk southbound towards the entrance, and there's no way that she would even know that that car is going to turn in at this point. Miss Fannin testifies she looks left, right, she's walking, she never sees the car coming up behind her at a fast rate of speed. So we'll click through the timing sequence, and next you can see the Ford turn, and at this point the vehicle's going 7 miles per hour, and she accelerates to 13 miles per hour, up to 15 miles per hour, and she accelerates forward towards Miss Fannin. Okay, now, this is a screenshot based on the engineering analysis from inside the vehicle of what Miss George would have been able to see. And there's no dispute that Miss George is standing right there, available for the driver to see her. But yet Miss George didn't slow down. She didn't try to safely pass the pedestrian. She accelerated straight towards her. In a case like this, we take deposition testimony of the witnesses. This is under oath. And this is what Miss George testified to about the collision and about the speed that she was traveling.
When was the first time that you ever saw Miss Fannin?
At impact.
At impact?
Yes.
So before impact, you did not see her?
Not at all.
She goes on to testify, out of the corner of her eye, she sees like a blur on the side of her vehicle. She never saw Miss Fannin up ahead. Okay, and that's where the impact occurs, the vehicle going 15 miles per hour conservatively. Now, not only do we have an accident reconstructionist to look at the physics behind the collision, we've hired an injury biomechanical expert who has assessed the medical evidence in the case, including the x-rays of the broken bones and the physical evidence to the vehicles, to put it all together. And this is Mr. John Bro. And they've done this analysis of the kinematics or the body movement of the pedestrian to cause these injuries. Bam. You can see how that twisting force would cause severe injuries. Now we're going to overlay this with some of the x-ray images. We'll slow it down here. You can see the ankle with the shin bone, the tibia, popping out of the skin, and that smaller bone's called the fibula. She had a complex fracture right in half. And then, of course, the severe shoulder fracture, which required 10 screws and a very large plate to fix all of those injuries. All right, now, the police investigated this collision. The CHP were on the scene, Officer Ramirez. He interviewed Miss George at the scene, and this is some of the data that he collected. Obviously, the safe speed here would be 5 miles per hour, according to Officer Ramirez. George told him she was going 15 to 20 miles per hour. No doubt that there's clear visibility for Miss George. And the physical evidence of the broken passenger mirror and minor scrapes to the passenger fender and the door. Now, the first actual witness on the scene, because unfortunately, there was no video surveillance of this parking lot at all. From any of the retail stores, nothing outside that captured this collision. But the Holiday Inn Express manager heard it, David Espinosa. He ran straight out to the scene. And Mr. Espinosa is under subpoena to testify in this trial. And based on his deposition testimony, Mr. Espinosa will say that he ran out and he said, "What happened?" And Miss George was panicking. And she said, I'm so sorry, I was distracted." And she motioned to her face like she was on her phone. But ladies and gentlemen, the defense has failed to turn over those cell phone records. Now, this is what Miss George testified to.
Did you tell the investigating officer that you were going approximately 15 to 20 miles per hour?
I believe that may be what I have told him.
And now you're saying that at the most you were going 15 miles an hour?
Yes.
And I believe earlier in your testimony you believed that the safe speed would be 5 to 10 miles per hour through a parking lot? Is that correct?
Yes, sir.
Okay. So based on your testimony, you were going faster than what you believed would be a safe speed in a parking lot, correct?
Yes.
Okay, so she admits it in deposition, but we're here today doing this jury trial because she's changed her opinion, apparently. Now, the defense, they've hired their own experts, and they're defending the case based on this diagram. Their accident reconstructionist, John Gardiner, drew up this little cartoon. This is all the work he really did in the case. And he believes that Miss Fannon's ankle injury is more consistent with Miss Fannon darting out in front of the car and getting hit by the bumper. That's his opinion. That's what they're going with. But ask yourself, what does the evidence in this case show? If that really happened, don't you think Miss Fannon would have a knee injury if she got hit by the bumper? Maybe some kind of knee trauma? Wouldn't she go up onto the hood and maybe have like a head injury? Or wouldn't there be some damage to the front of the vehicle if the front bumper struck a pedestrian at 15 to 20 miles per hour? None of that exists. Do you think they'd have a witness to say, oh, I saw this 56-year-old executive woman dart out in front of the car? But they don't have any of that. No evidence whatsoever. And of course, there's no evidence that Nancy Fannon was on her cell phone. Now, this is what Miss George said at the end of her deposition. Take a listen.
Did you feel at the time like you could be responsible because you felt that when there's a collision of a vehicle and a pedestrian that the vehicle is responsible for the collision?
Yes.
So she thought she was responsible then, but she's not responsible now. Okay, so this is a clear case of liability based on the evidence. The real question for you, ladies and gentlemen, is what is the full and fair compensation for Ms. Fannon in this case? Okay, so to start with, I discussed the left ankle fracture, the tibia through the skin, the 4-part shoulder fracture. She had 4 surgeries. She now has 20 screws, 2 large metal plates. She was in the hospital for 2 weeks. Tremendous physical pain. This is a diagram based on the x-ray. It's called an eversion ankle injury, where the ankle rolls inward. Her ankle will never be the same, there's no dispute. So the first surgery she had on the date of the incident, they put an external fixator, this cage that went all the way around her foot and ankle, and they actually had to cut off the bottom of that shin bone, that tibia, just to get it back into the skin. Then 2 days later, they had to let Nancy stabilize, and they did another surgery. And this was to her shoulder, where they went in and had to do an entire plate to keep those 4 pieces together and put in another 10 screws into her shoulder. Another 2 days later, a third surgery. This is where they put in the hardware into her ankle to keep that severely fractured ankle back together. But unfortunately, that ankle injury was so severe, the way the shin bone popped through, it left a massive hole in her leg. And so the doctors had to do a very severe skin grafting surgery where they basically did a full thickness skin graft from her upper leg. They just cut it out, and then they put it back on to the ankle, doing a plastic surgery to cover up that grotesque wound on her ankle. This is a timeline of the initial treatment of all the surgeries. But to Nancy's credit, she's made a tremendous recovery. And it's because she did 68 physical therapy visits during about that first 6-month period, just so she could learn to walk again. She had a wheelchair for a long time, but she's a tough lady and she got back on her feet. And she'll testify in this trial, walking in here without a cane. Now, undisputed past medical expenses of $130,000. There won't be any argument about that in this case. The future medical expenses are hotly disputed. The defense would like you to believe that Ms. Fannin needs 0 in terms of future medical care, despite her ongoing pain and dysfunction. Now, this is a foot and ankle expert, Dr. Williams. He's recommending that Ms. Fannin have a complete ankle hardware removal surgery and then an ankle replacement so that her pain diminishes so that she could walk like she once used to be able to do. This is a current x-ray. You can actually see that there's 2 broken screws in her ankle, and yet the defense experts think that's fine. Just leave it. Just leave those broken screws in there. They want to give her 0 to try to fix that. And the question for you is that a reasonable position to take? Okay? She needs a hardware removal, no question, to fix the broken screws. And this is what the total ankle replacement surgery looks like. It's very invasive, there's no question about that, but Nancy wants to have it done so that she can do some of the things that she used to enjoy. This is the shoulder expert, Dr. Mealer. He's recommending a total shoulder replacement because as you can see from this x-ray, one of the screws is actually pointing directly into the socket. So every time Ms. Fannin moves her arm, there's like a pin grinding on all those tendons. But yet the defense, they don't want to give her any money to fix this issue either. This is the report from the shoulder. She actually has what's called a non-union. And you can see it here where the shoulder expert will discuss these black marks and what that means. The white is the bone. These black marks, that means there's no healing there. So she has these loose pieces of bone in her shoulder that need to be replaced with a total shoulder replacement. And that's a diagram of it's an invasive surgery, no question. But again, this is something that Ms. Fannin needs to help her for the rest of her life. She's now 60 years old. She has another 25 years of expected lifetime. So these are issues that she needs to address now. So the reasonable cost of the future medical care will be right around $500,000, and that will be supported by the evidence in this case. All right, now, this is the defense expert that they've hired to evaluate Ms. Fannin's orthopedic injuries. I had the pleasure of taking his deposition and asked him some questions about what he thought with respect to Nancy's orthopedic injuries. And here's what he had to say.
And she's never going to get back to where she was before the incident, correct?
That's probably correct, Jeff.
All right. And her complaints were reasonable given her medical condition, correct?
Yes.
All right. So your terminology is she had an extremely severe set of injuries, correct?
Correct.
Extremely severe, no dispute about that. All right. This is our vocational rehabilitation consultant. Ms. Fannin had to quit her job as a regional director as a result of these severe injuries. Her job required her to travel at least twice a month, traveling to Hawaii, Nevada, Arizona, California, and she just can't do that now with her severe injuries. So she quit her job where she was making about $100,000 a year, and she took a desk job near her hometown where she only makes $60,000 a year. So there's about a $40,000 difference every year going forward during Ms. Fannon's work life. Now, we've had an economist do the numbers of what that all means. And the bottom line is she has at least $650,000 in lost earnings in this case, depending on the scenario. All right, now, this case really comes down to the non-economic damages in this case, which are the physical pain, the emotional suffering, the disfigurement, the loss of quality of life, the grief, the embarrassment, the humiliation that Ms. Fannin has had to go through as a result of these horrific injuries. Now, to start with, let's think about the past non-economic damages, which really are the past 3.5 years since this incident occurred. We talked about those 4 surgeries, living in a wheelchair. She lives in a 2-story home, and she had to have a hospital bed brought in to her living room with a bedside commode, where she lived for 3 months, and her husband and her 2 grown sons had to care for every need that she had. So think about that in terms of the embarrassment and the pain and emotional suffering that she went through during that recovery period. The 68 grueling physical therapy sessions that she went through just so she could learn how to walk again. Think about the post-operative recovery for someone that has a severely fractured left ankle like this, where she could have lost her foot. You can see how swollen it is with the staples, the skin grafting. And this is months after the incident, and you can see what the incision looks like. Even her shoulder, her entire left side was completely bruised. The pain was horrendous. She couldn't sleep for the first 6 months. This is Nancy at home during her recovery period. That huge cast. You can see the atrophy in her leg, and of course that skin graft on her left upper leg. Now, really though, the past, what Nancy's gone through in the past 3.5 years, that's nothing in comparison to what Nancy will go through for the next 25 years of her life, dealing with the physical pain that she has every single day. Now, she's a woman that doesn't take narcotics. She wants to stay away from those medications, but every day she takes Tylenol and Advil and Aleve just to deal with the inflammation and the pain that she has. Here's some photos of Nancy before the incident. She used to love to do these charity 5Ks with her family and her friends every year, multiple times a year. Nancy can't walk a 5K now. She can barely walk a 1K with pain, and then she pays for it afterwards. Her life has been dramatically affected. This is Nancy about 10 years before the incident. As I mentioned, she was an avid hiker. She loved to fish, loved to be in the lake. There's no way she could stand in rocky, shallow terrain like this again. She has a difficult time even going camping now because of the uneven surfaces that she would encounter. They live out by Reno, and in the winter it snows there. They have 2 dogs. Nancy used to every day do a 2-mile loop up this hill in their neighborhood. She can't do that now. Now she's lucky if she can walk on an indoor treadmill for 20 minutes. This is Nancy and her husband Jim in New York, just 2 months prior to the incident. And if anyone's been to New York, you know you have to walk everywhere. It's hard to get taxis. You're on your feet all day. Nancy can't do that now. In fact, she tried, and they had to come back early because she was in so much pain. So she can't do these trips, which she used to enjoy. And as a woman who is 60 years old, she's trying to enjoy this part of her life, traveling with her family. And she's got significant pain and discomfort trying to do anything physical. And probably worst of all, Nancy has this 2-year-old little grandson. And she fears, Nancy's not quick on her feet. She certainly can't run. She can't scurry to get a little kid. And she has a hard time even picking up her 2-year-old. And as a new grandmother, this greatly affects the psychology of Ms. Fannin and the mental suffering that she has going forward. So with that, ladies and gentlemen, at the end of this case, we will present an abundance of evidence to support a substantial multi-million-dollar verdict for Ms. Fannin. So thank you for your time and attention.
Holy smoke, good job, huh? Wow. We didn't even talk, but I looked through this and I thought, oh, he's got a theme. Persons who speed and hit someone are at fault. He did a story with no notes. His notes for the PowerPoint when he needed it, but at first, when he told you the first story, he didn't even need it. Did you notice how he went through the major players and the people that were for him, his experts, and everybody were smiling and looking very professional? And the defendant and the defense expert, they didn't look quite as good, did they? Yeah. I noticed also when he gave words like Kytomax, he's like, oh yeah, they're going to have an expert on Kytomax body movements. It's tell them in simple language. His tech was working, right? And boy, do we remember the dramatic parts, like the tibia popped out? Yikes. And what about the defense? The defense is going to show you a cartoon, right? And he asked at the very end for exactly what he wanted. Now, we didn't even talk, but all those things I thought were really well done. So we'll move on, and next is Amy Rose Martell.
Thank you. The best part about being a plaintiff lawyer is I normally go first, so I don't have to follow people like Spencer. May I proceed, Your Honor?
Yes, you may.
All it takes to knock down a row of dominoes is one move. One bad move or one choice can set a chain of events in motion. And although we might like to think otherwise, the same is true in medicine. We trust our doctors, but one bad choice, one negligent act by your doctor can lead to a chain of events, a series of injuries that can have devastating consequences for the patient. And you will hear that that is exactly what happened in this case. In 2016, Shirley Adams had spine surgery. And the choices made by her surgeons and the doctors that took care of her during the hospitalization afterwards, their choices, their negligent acts led to like a row of falling dominoes, a series of injuries after injuries. For Shirley Adams, it was a nightmare. A nightmare that ended with a permanent nerve injury and her bowel rupturing. It literally exploded. So let me back up and tell you a little bit about Shirley Adams to put all of this in context. This is Shirley in 2016. She was 60 years old. She was engaged to be married. She had 2 grown daughters, and she was the vice president of General Dynamics IT department. She was active. She liked to paddleboard, hike, surf. She did everything with her family and friends and her 2 grown daughters. But you'll hear that 2016 wasn't the first time that she had back problems. Her problems began years earlier. In 1986, she had a herniated disc, and in 1995, she was involved in an auto accident, and so she had some back surgeries that involved having screws in her back. But after these surgeries, she went back to her normal activities. And in fact, this photo is from 2014 when she's skydiving. These back surgeries didn't stop her. They helped her. But as time went on, and in 2015, her back problems started hurting her more and more. And so she saw her primary care physician, and she couldn't deal with the pain anymore. Advil just wasn't cutting it. So her primary care physician referred her to a neurosurgeon, Dr. Black. Dr. Black recommended that she have another surgery. He wanted to extend what's called the fusion by adding some more screws to the L3, L4 region of her back, right in the mid to lower back. Well, as anybody who's ever had surgery might appreciate, Miss Adams was terrified to have another surgery. They're not fun. But Dr. Black told her that he'd done the surgery hundreds of times and that he would use the best team, the best techniques, the best tools, and that she would feel better after her surgery. Of course, there's no guarantees, but he was the expert. So Miss Adams trusted Dr. Black, and on June 21st, 2016, Miss Adams went to Sharp Memorial Hospital to have back surgery. Well, when she gets to the operating room, they wheel her in on the table, and they actually have her with right side down. So she's laying with her left side up. Now, in the operating room, she's on the table. The neurosurgeon, Dr. Black, he's standing to her side. At the head of the table by the patient is the anesthesiologist. He's keeping her under, and he's making sure her vital signs are stable. All around, you have technicians. You actually have big screens like you see here, because with the doctor's tools, they can watch what they're doing as they go in real time. And on the other side of the patient is another surgeon. This is a general surgeon, Dr. Bean. And you'll hear that the reason Dr. Bean was in the room is because Dr. Black's choice and how he wanted to approach this surgery was to do it in 2 stages. The first was with the patient lying on her right side, left side open, or left side up, and they were going to cut her open to access her spine through the left side. And the reason the general surgeon was there is what Dr. Black will tell you, because anytime I go anywhere near the belly, I have an expert there. I'm not a belly surgeon. So I have Dr. Bean there for every time I use this approach. The reason is because there are critical organs in this side of the abdomen. If you look under your 11th rib, you have the kidney and you have the bowel. What you see highlighted is the large bowel. You have the small bowel, your intestines all wound up in the middle. They connect to what's called the cecum, goes up your ascending colon, across the transverse, and down the descending colon. And that descending colon is right in the region where Dr. Black was going to perform the surgery. So what he told me in his deposition is, I always have the belly guy there. I don't go near the belly. And he told me that in Miss Adams' case, he had Dr. Bean there, and Dr. Bean did the approach. Well, what the evidence will prove in this case is that first domino that fell was Dr. Black's choice that day not to use the expert, not to use the belly guy standing right here to make that approach, but instead Dr. Black decided to make that approach himself. Now, it's not that he's not qualified, but the approach surgeon, that's all he does. He is the specialist. That's why he's there. But this day, he just held the retractors. And that was the first choice. So Dr. Black makes the approach. He goes in and he removes the disc. And then as he's getting ready to close her up and flip her to the next side of the procedure, he places a surgical drain in that area. And where the 11th rib is right where you're going to see that goes up on the transverse colon and right before it goes down to the descending colon. It's all your bowel. He places a surgical drain that's a long tube, has holes in it, comes out the patient, it's sewn in, and on the other end is a long suction bulb that takes out the fluid. So he closes her up. Again, the belly guy is normally there to close her up, but he's just holding the retractors. So Dr. Black closes her up, flips her over, face down. He then opens her back with another incision, and that's where he's trying to take out the old rods and screws that she had and put in new ones. But again, Dr. Black didn't make the right choice. He didn't have the right tools with him for this surgery. So as he's pulling on these rods, he can't get them out because he doesn't have the right set of tools. So he improvises on this day. And what you'll hear is when he's removing the rods, he can't really get them out, and so it's taking too long. You can only be under for a certain amount of time. So he's sort of under some pressure. So when he gets these rods out, he finally gets that part of the process done. He's then moving in to put in new pedicle screws. You'll hear a lot about pedicle screws. They look a little bit like a screw that goes into drywall. They're threaded on the end. So when you're putting these screws in, what you will hear from the experts in this case, and I have an expert neurosurgeon, Dr. K, who's going to come in, and he's going to tell you that what's the most important thing to do is keep those screws parallel and in the bone. You want them parallel so that you get the most stability, and you want them in the bone because if they're too long and they go through the back of the bone, they will hit your nerves that run down your spinal column. All your nerves go right down the middle of your spine, and they go through all your legs, both your legs. And the reason why you don't want these screws being too long is because it can cause permanent nerve damage. And Dr. Black will tell you he knows this, and he's never put a screw in that's too long. So Dr. Black is putting in these screws, and he is using his live x-rays. It's called fluoroscopy, and he's taking pictures during the procedure so he can make sure he gets these screws in right. Now, he's going to tell you he did it right, just like he always does. But what the evidence will prove in this case is that he didn't. What we have here are Dr. Black's own images taken intraoperatively of Miss Adams' back. And what you will see and what we have circled here are the L3 screws. The screws on top, my expert Dr. K will tell you, those are placed correctly. They're more parallel. The second set of screws, they're pointing towards each other. That's called medial. And there's not as much bone on the backside, which you can't see, but we'll have other photos to explain to you, is that because they're going medial, there's not as enough bone on the back of that, and so they're breaching or going through the back of the bone, and they're actually touching Miss Adams' the nerves that run down her spinal column. So what Dr. K will explain to you is that when Dr. Black saw this photo intraoperatively, what he should have done is taken those screws out and put them back in correctly right then and there. Avoid the chance that there could be an injury to this woman's spinal column. But Dr. Black chose to leave them just like this, to leave them how they were. He knew how they were, and he left them like that. That was the next domino that fell for Miss Adams. But unfortunately, it didn't end there. Because Dr. Black finishes his procedure, he sends her to recovery, and over the next few days, it got even worse for Miss Adams. Because what happens after surgery to your bowels is that it can take a while to sort of wake them up. And it takes a while before you can have gas or have a bowel movement. So it's one of the things the doctors are always checking when you're in the hospital after surgery. But what happened with Miss Adams is she wasn't having any gas and she wasn't having any bowel movements. And so by the third day, she hasn't barely eaten. She's feeling horrible. What she notices is her stomach is completely distended, like she's 9 months pregnant. Her belly looks humongous, and she is in a ton of pain. She's begging the nurses, who are giving her milk of magnesia, laxatives, suppositories, and 2 tap water enemas. None of that works for Miss Adams. She is still in excruciating pain, so the doctors order a CT scan of the abdomen. That is, like if you've heard of an MRI, these are images that are better quality than x-rays, and they will show you like a slice of bread. They will take slices of your spine and your belly as it goes down. And what the evidence will prove in this case is that when she had that CT scan, it showed that there was a bowel obstruction in the descending colon, the portion of the colon right where the surgery was performed, right where that entry was made by Dr. Black. Now, a bowel obstruction, think of a hose, right, that has water coming out of the spigot. If you pick up that hose and you squeeze some of it, you'll have little bits of drips of water that come out, but that water stops flowing and creates more pressure on the back of the hose as it goes towards the spigot. A bowel obstruction is like that kink in a hose. Her CT scan showed that there was a kink in her bowel, in that hose, right at the area where Dr. Black made the surgical approach, and right in the area where he placed his surgical drain. In fact, on the radiologist scan, and I'll have a radiologist come in and he will explain all this to you, but you can see there's some white on the side. There's some arrows pointing right to the surgical drain, going around the descending colon. The radiologist put in his report, I can't rule out that there is an injury to the descending colon caused during surgery. So because of this, another expert was called in, another surgeon, Dr. Clay. He had one job, make sure her bowel is okay. So Dr. Clay comes in and he examines Miss Adams and he notes her belly does look like she's 9 months pregnant. She came in weighing 140 pounds and she's my height, 5'10". She did not come in looking like she was pregnant. He'll tell you she was in pain, and he looked at the CT scan, but he thought to himself, he will tell you he made the choice. There's no drain wrapped around her colon. There can't be an injury at the exact same place where Dr. Black made the approach. There can't be an injury at the exact same place where that drain is. It doesn't make sense. That was Dr. Clay's choice, because what he decided is, instead of listening to the radiologist, was that she had a slowing of the bowel. It's a symptom called ileus, okay? So think of a hose again, and if you turn off the spigot, there's still water in that hose. It's not moving, okay? Your bowels, when they are working properly, there's muscles that go all along that push everything through the bowels. But an ileus is a condition where you turn off that spigot and there's still water, but it doesn't come out. Now that's different than what I told you earlier, the kink with the bowel obstruction. And the difference is, and the experts will explain, you'll hear from my expert general surgeon, Dr. Leo Gordon. He's going to come in and tell you the difference between just the water being turned off and the kink is the kink or the bowel obstruction requires surgery to resolve. But Dr. Clay didn't think that's what she had, so instead of taking her to surgery, he just took her off the narcotics. He said that she could no longer eat or drink, and he put a tube down her nose, an NG tube. And the point of that tube was to suck all the air and fluid out of her stomach because she had been vomiting. So he chooses to not take her to surgery, but to leave her lying in her hospital bed. The next day, same pain. The tube helped because it's sucking all the air out, but he has another x-ray done of her abdomen. And you're going to hear from the radiologist that took that next film, that was Dr. Chang. And he's going to tell you that when he saw the belly and he saw the images, he called up Dr. Clay and he actually looked at the CT from the day before and he said, there is a surgical drain wrapped around her colon. And her cecum, which is the small part at the end, it's double in size. There's a blockage. And as a result, things are blowing up. They're getting double in size. But Dr. Clay will tell you he didn't think that was possible. Again, he chose not to believe the second radiologist. She couldn't possibly have a drain wrapped around her descending colon. She couldn't possibly have an injury in the exact same location where Dr. Black did his surgical approach. So again, Miss Adams lie in her bed. Day 7, day 8, 10 days she's lying in bed, no food, no water. She is literally being pumped full of laxatives on her IV. They're not working. Dr. Black comes back in, he finally pulls that drain out. And what do you know? The next day she starts having a little bit of gas. Well, this makes her feel better. It sounds silly, but having that little bit of relief made her feel better. And by July 1st, 10 days after her surgery, she has her first little bit of watery diarrhea. And Dr. Clay will tell you he thought that was a fantastic sign. Things were getting better. But he knew that she plateaued. She really wasn't that much better. So he orders another CT scan of her abdomen. You will also hear from Dr. Puck, the third radiologist. He's going to tell you that although the drain was gone, when he looked at the next CT scan, he found well, let me back up. What Dr. Clay said to the radiologist was, get another CT scan. Does she have a mechanical obstruction? Those are literally the words he put in his order. Does she have a mechanical obstruction? The radiologist writes back, yes. She has findings consistent with a mechanical obstruction in the exact same area the other two radiologists said that she had a bowel blockage. And not only that, not only did she have the blockage, but worse. Now she has air in the wall of the cecum. Those black spots up there, they're not supposed to be there. Your bowel's not supposed to have air in it because when it does, that's a sign that there's too much pressure and your bowel is dying. And that's what was happening to Shirley Adams. Her bowel was dying. But instead of taking her to surgery, which my expert will tell you is exactly what should have happened, she should have been rushed to surgery. Instead, Dr. Clay made the choice to go on vacation. He looked at the CT scan. He looked at the radiologist's answer, yes, she has a mechanical obstruction. But what he did is he said, I still think it's that ileus. I'm going to give her some antibiotics. He passes her off to his junior colleague, a doctor of osteopathic medicine, and says, get her a colonoscopy. He leaves for vacation. Miss Adams lie in bed in pain day after day. They'll tell you, you're going to hear from the defense, but she was better. She was having diarrhea. She was better. Well, on July 5th, we have evidence she wasn't better because her cecum blew up. Like a balloon, it popped. She had feces throughout her abdomen, and you will hear that that is a life-threatening condition. She was rushed to surgery. Dr. Clay was back from vacation by this time. He took her to surgery, and what he found at surgery, right where the 3 radiologists told him there was a bowel obstruction, right where that drain was, he found a tight-knit knuckle of bowel adhesed down to the back of wall of her retroperitoneum, the back of her belly, which is exactly where Dr. Black was. Exactly where the radiologist told him to look. And there was so much damage that what you will hear is as a result of the rupture and the obstruction, Dr. Clay had to perform an ileostomy. And that is essentially where they detach your colon and they pull it out through your abdomen. And instead of going to the bathroom like the rest of us, you have a bag on the side that collects your feces. That's what Miss Adams woke up with. But as if that wasn't enough, those dominoes continued to fall for Miss Adams. Because when she got home and she was recovering from her surgery, those misplaced screws started causing her severe, burning nerve pain. Now, she'll tell you she had pain before. She got back surgery because she had pain. You don't get this surgery because you feel great. But she's going to tell you the difference of that pain and that burning pain. She's going to tell you she told Dr. Black time and time again about it, but he just kept telling her, it's normal, it's normal. Finally, she gave up on Dr. Black and she went to a new neurosurgeon. And that neurosurgeon took a CT scan and said exactly what we see on the intraoperative x-rays. Those screws are breached. They're poking through the back of your pedicle, which is the bone, and they're poking into your nerves. And guess what? You need another surgery. Dr. Black's own expert, Dr. Roberts, will come in and he will agree with us. Those screws breached through the back of the pedicle. Now Miss Adams needs another surgery. She will tell you about the prospects of going under, how that terrifies her. She needs these screws removed because they're poking the nerves on her spine. And because of that pain, because of the pain of those screws and all of the issues with her bowel, she will tell you that her life has been forever changed. She lost her career. She tried to go back to work. I mean, she was a vice president. She'd tell you that the first time she goes back to work and she gets up at a big conference like this, she stands to talk to her colleagues. She's petrified of the mic on her lapel because her bag makes so many noises that are awful. And she's standing there, and the bag, which she has to change every 2 hours, starts to leak. She'll tell you about that humiliation. She'll tell you about what it's like to change that bag every 2 hours, how she doesn't sleep because of it, how the burning pain down her leg, how while she tried to work, her doctors ultimately put her on disability because the pain was just too much, all of it. It all wound up. She can't sleep. The backs of her legs are burning at all times. You're going to hear she was earning $250,000 a year. She's now at home, and on a good day, she walks around the block twice. At the end of this trial, I'm going to ask you to compensate her for all of this. I'm going to ask you to compensate her for her humiliation, her pain, her suffering. And I am certainly going to ask you to compensate her for that next surgery that she needs. And so at the end of this trial, we're going to have to decide, were those choices by the doctors, were they negligent? And I think what the evidence will prove in this case, I think the radiographic evidence itself The black and white images, this is not going to be about my opinion or what some other doctor thinks. We will have black and white evidence that show you these doctors were negligent. Thank you.
I don't know about you guys, but I would settle that case. And boy, that was really good, right? Did you see her theme about the dominoes, the no notes, and how much, she used like the technical terms that were used for medical expressions that were used, like the bowel exploded, the bowel was dying, instead of saying like, the technical terms that would be there. She walked around an operating table. You knew where everybody was and what they were going to do. Wow. And how about the analogy to the bowel being like a hose? That really made it clear for all of you too. And she asked for what she needed at the end. Really great job with the dominoes falling too. Great job. Yeah. Spencer. Yeah, it's all yours.
Well, I want to take one more opportunity to thank all of our panelists. If we give them another round of applause for an incredible job. I hope you all enjoyed this exhibition. We're going to take about a 5 to 10 minute break, cycle back in here for our second panel. So go stretch your legs, grab some water. We'll see you shortly. I hope we put too much. No. Right? Because we started about 10 minutes late where I had to get rid of something. I think you're right in the range where we should have. Everybody did an amazing job. Thank you so much. Yeah, absolutely.